On behalf of parentalrights.org and Parents' Rights US and a rapidly growing number of allied organizations, I want to thank Senator Jim DeMint and Congressman Pete Hoekstra for their leadership on this important issue of amending the Constitution of the United States to introduce the concept that parents' rights need to be a protected, enumerated right in the Constitution. There are two basic rights two basic reasons that you ever amend the Constitution. One is to preserve our law and traditions from potential threats and erosion of our rights. The Bill of Rights serves as the chief example of amendments that are designed to preserve the existing rights of the people. At other times, it's absolutely necessary to change the existing law. The 13th, 14th, and 15th Amendments were clearly necessary to end the evils of slavery and establish the principle of equal protection for all Americans. The Parental Rights Amendment follows a pattern of the Bill of Rights. The goal of this amendment is to preserve our existing law and traditions against judicial erosion and the ever-growing threat of international law. Sections 1 and 2 of this amendment do nothing more than restate the time-honored doctrines of the Supreme Court on parental rights. We are simply changing parental rights from an implied right based on judicial opinions to an express right based upon the actual constitutional text. Section 1 faithfully employs the words and phrasings of the Supreme Court's decision in Pierce v. Society of Sisters from 1925 to declare that the liberty of parents to direct the upbringing and education of their children is a fundamental right. Section 2 carefully follows the words of the Supreme Court in Wisconsin v. Yoder from 1972 to declare that parental rights, while very important, have limits. The government may intervene when the interest is of the highest order and not otherwise served. This section is a correct statement of current law. Today, when the government has proper evidence of child abuse or neglect, for example, it may and should prosecute a parent who is responsible for such behavior. Section 2 ensures that this principle remains intact. Parental rights are fundamental, but they are not absolute. Section 3 preserves the current principle that only American laws govern the relationship between parents and children in this country. The use of international law is a rapidly growing trend in our judicial system. One federal district judge in New York has on 2 separate occasions ruled that the UN Convention on the Rights of the Child already binds the United States under the doctrine of customary international law. An Ohio court ruled on an obviously flawed premise that the Senate had already ratified this treaty, which of course it hasn't, and therefore, based on that ratification, ordered parents in the case before them to stop smoking in the presence of their children because it harmed the health of the children. Section 3 of this proposed constitutional amendment makes it clear that the only law that can be used in American courts regarding American families is the law made in America by our own legislatures or by the people themselves. The use of international law for domestic purposes is utterly contrary to the idea that this nation is a self-governing republic. This section is necessary, especially in the context of international law. Under the Vienna Convention on the Law of Treaties, international legal obligations are of superior rank to all forms of national law, even our Constitution. However, there's an exception. Under Article 46 of the Vienna Convention on the Law of Treaties, a national constitution that deals with the capacity to make treaties is an exception to this primacy of international law, even in international tribunals. Thus, Section 3 makes it clear for domestic law purposes and international law purposes that it is illegal to use a treaty to overturn parental rights in this nation. This should be a bipartisan issue. President Obama recently declared, in the end, there is no program or policy that can substitute for a mother or father. Every member of Congress who agrees with the President on this principle should be in favor of this amendment. Every member of Congress who believes that Pierce v. Society of Sisters was correctly decided should be in favor of this amendment. Every member of Congress who believes that Wisconsin v. Yoder was correctly decided should be in favor of this amendment. And every member of Congress that believes that American legislators only should decide our public policy on this subject should be in favor of this amendment. On this last point, a post-election Zogby poll sponsored by WorldNet Daily makes it clear that virtually every sector of the American people agrees with this last proposition. When asked if they wanted American judges to use only American law or American law mixed with international law in our courts, the public was overwhelmingly against the idea of using international law for this purpose. The majority of Republican voters reject international law. So do the majority of Democrats. Those who voted for McCain, those who voted for Obama. The majority of union members reject international law. NRA members reject international law. Every region of this nation rejects it, every age group, every racial group. This is a bipartisan issue among American voters, and I truly hope and believe that it will become a bipartisan issue on the Hill as well. The gap between the values of the Hill and the values of the American people has grown too large on too many issues. The very best place to start to show the American public that we can work together for shared values is here to protect the American family. Thank you very much for coming today, and it's my pleasure to introduce Senator Jim DeMint.
Thank you, Mike. Thanks for your organization, Fighting for Parental Rights. I'm honored to stand with Congressman Pete Hoekstra and Frank Wolf. Thank you for your leadership in the House. It wasn't too long ago when it would have been inconceivable for the government to prohibit prayer at a football game. And even 10 years ago, those who proposed a constitutional amendment to protect marriage were considered somewhat radical and that their move was unnecessary. But we found that it was not unnecessary at all. You would think in this country that parental rights would be one of those inalienable rights granted to us by our God. But the activist courts are proving us wrong almost every day. You wouldn't think we would need an amendment to allow a family to raise their own children, but clearly we do. Family, faith, and freedom are under attack in this country today. And those who want more centralized government, a more powerful government, know that they have to undermine the family and faith in order to reach their goals here in Washington. It's critically important that we protect the rights of parents to make the decisions for their children. Because it's clear if you watch Washington at all, we are not capable of making good decisions for parents or for businesses, for banks, or even for ourselves. This is something that we need to fight for. That's why I'm supporting a constitutional amendment that would establish those rights for parents that I believe are inalienable. And I will work with the members of the House and outside organizations like Parental Rights to make sure that this is brought in front of the American people in a way that they can understand and appreciate. And we know if they do, as Mike just said, that the wide majority of Americans believe in parental rights rather than government intruding into the home. Thanks again, Mike.
You know, some folks might ask, why are we doing this? I think Mike explained at the intellectual level. I can't quite get to that level sometimes. You know, Jim talked about some of the other assaults. You know, there are assaults going on from at the international level. There are assaults going on from our own courts. But one of the places that we really need to watch is that building right behind us, the U.S. Capitol. It was only about 4 or 6 weeks ago that we're in a markup in the Education and Labor Committee, and there's a bill going through, and it says that for kids in certain conditions, if the social worker and the doctors want to prescribe medications for those kids, the parents will be notified. I thought, that's not right. If you're going to be making that kind of a dramatic treatment about a child, the parents shouldn't be notified. The parents should be consulted, and the parents should have to give their approval. Just one small example. So we draft an amendment and say, you know, before treatment can be prescribed for your child, the parent will have to be notified, and the parent will have to be consulted and approve of that treatment, and have to approve of that treatment. Kind of a no-brainer. Problem was, it was a no-brainer for the other side. My amendment was proposed, and it was defeated. Just a small erosion of parental rights and freedom in America. It happens every day in that building behind us. This constitutional amendment is needed to stop that erosion and to clearly articulate that when it comes to the upbringing of our children, It is the parents' rights and not the government's. The good news is that as we introduce and as we drop this bill on the House side today, we will have 70 co-sponsors with us in this legislation. And I know that we had some young people who were very concerned about that. Congratulations and thank you for being here to stand up for the freedoms and the rights that the Constitution gives you, and helping us make sure that that Constitution reflects all the freedoms and the rights that we want you to have. But they went around Capitol Hill today talking to senators, talking to members of the House, talking to staff, and saying, we think that this is important to get done. So as Mike said, we've got a growing coalition of members on the House, members in the Senate, and outside interest groups, but most importantly, we're on the side of the parents, we're on the side of the people as we move this issue forward. So thanks for being here, and we'll turn it over to Frank. Thank you for being here and being a great help on this issue.
Thank you. I'll be very brief because Mike and Jim DeMint and Pete Hoekstra have covered it, but as a father, as a parent, you would be surprised that this would even be necessary, but after the California decision and a couple of the opinions from the Supreme Court, I think that we do need it. So I'm prepared to work with Pete and Jim DeMint to do everything we possibly can to make sure that we pass it as early as we possibly can. And Mike, thank you for your leadership.
Just say one thing in closing. First of all, thank you to Congressman Wolf, who's my congressman. I'm very proud that he's the second sponsor of the amendment right after Congressman Hoekstra. The experience that Congressman Hoekstra relayed to us reminded me of an example in 1994 when in H.R. 6 there was a provision by the Northern California Congressman George Miller to require a certain teacher certification rule that would have eliminated the ability to homeschool. And even though there was the Clintons were in the White House and the Democrats were in control of both houses, 8 days later, a provision to take the exact opposite position passed 422 to 1. And the reason that happened is because the American public stood up and spoke up and said, we want to protect parental rights in education. I believe the same thing can happen yet today. Despite the political climate here in Washington, when the people of America stand up and speak up, anything is possible. So thank you for being here, and thank you so much for your leadership.
Thank you.